There is this checklist which we really value, and we think this is the best shortcut you can have when you go to draft a contract, which actually explains all the major heads that are there in any contract and also gives a summary of each clause. Now, you may not understand the summary here, but there are detailed chapters below which will tell you what is the meaning of each clause. Like here, we've written, for example, obligations of the parties plus consideration. And you may not understand this fully here, but then you can open to obligations and payments clauses here in detail, and then you will understand everything because this is given in a huge amount of detail, okay, with sample clauses. So these are the heads of clauses. So the first part is the title to the agreement. Title is not legally binding. It just gives you a sense of what the agreement is about. Preamble is the recitals, which means those whereas, all the paras beginning with whereas. This gives you a background of the contract, helps in understanding the commercials of the deal. Let me see if they are putting preambles in the government's clauses. They have a big preamble, right? Okay, here. This is the preamble. So I can understand, okay, this is happening under Article 297 of the Constitution of India. This under this act. So basically the whole background, the whole question, no, Jasmine, you were saying, how do I understand a new industry? Everything for me is given in the preamble. This is something great that the government has done. They have listed out the source in a very high level of detail. They've even went down to the rules that govern the whole issue, Rule 5 of these rules. So that's great, right? That gives you a whole picture. Now that's the preamble. Now we move on. Definitions. Now you can define important terms the way you want to. Okay, the government has defined it like this. So many definitions are now. These definitions usually become specific to the area of work that is being dealt with. Effective date could be a different date from the date of signing because the contract may be effective from a different point in time. Obligations of parties and considerations, this is the heart and the meat of the contract. Term, again, the heart and the meat of the contract. Termination, yes, an important clause. Covenants are in detail specifying the duties of each party. Okay, so these are about the little technical details that you want. Obligation will be like a big substantive obligation. I will take this house on rent. I will purchase this house from you and pay you this amount of money. I will, as a bookseller, publish your book as an author and distribute it across India. That's like an obligation. Okay. Consideration is you'll be paid royalty for this. But what is the covenant or duty would be, okay, you'll be paid royalty every month by the 7th. That will be written in the payment clause, but I will pay royalties on time on a monthly basis, covenants. I will give you statement of sales, covenants. Okay. I will not cheat. That's a covenant. So these kind of sort of smaller promises about each element of the obligation is a covenant. Representations and warranties is like, saying what I'm doing currently. Like if I'm a publisher, you approach me and you say, hey, will you publish my book? And then I'm assuming, right, that this guy is a publisher. So you will say, the representation will be, yeah, I'm a publisher, I'm validly constituted, I have all the necessary licenses to publish your book. Suppose every book published needs a registration under law, under present registration of Books Act. So suppose I'm a publisher and I don't even have this kind of procedure, okay? And there's an illegality I'm committing by publishing books because I don't even register them under the applicable law when I release a new book. That means that, I'm violating something. And as an author, you wouldn't expect that. So you will take a representation that performance of this agreement is not that you will perform this agreement in accordance with all applicable laws, you do business in accordance with all applicable laws, and you will not violate them. That's like so everything about the past and present is representations and warranties. Everything about the future that you will do is a duty or a covenant. Just remember this. So I get into the deal based on what I think you've done and you are today. And there are certain things you promise to do in future, which is the covenants. What you say you are or you've done is representations and warranties. This is the simplest possible breakdown of this concept. Indemnification. So indemnification is about if there's a loss caused by my actions, then I will make it good for someone else. So what happens is, say I'm an author and I go to a publisher and I say to the publisher that please publish my book, and the publisher happily accepts. Tomorrow the publisher realizes that my book is actually a copy of a book from a best-selling author. Maybe I've copied something from Tony Robbins' book, and Tony Robbins sues me and claims damages. Okay, and now he's not going to sue me; he's going to sue the publisher because that's whom he sees there. And now publisher will not say that I'm going to pay you, because he's going to say give me indemnity. All the losses and all the expenses of defending this proceeding or even removing the book from distribution, whatever losses I've incurred because of you, you need to pay me, because you falsely represented that this book is written by you and it's actually a copy of Tony Robbins' book, which is why I'm having to make extra payment to defend myself, and I may have to pay compensation to Tony Robbins. Then you need to personally indemnify me. That's the meaning of an indemnity clause. In every contract, you have to see what are the ways possibly which will get, in which your indemnity can get triggered or indemnity of the other side should get triggered, and then draft it accordingly. Most of the negotiation that parties do often borders around representation and warranties, indemnification, and covenants. This is once a deal structure is fixed. If you are going into a situation where there's no deal structure fixed, then the whole contract is open to negotiation, conceptualization, structuring. But when you have to actually, when you have standard form contracts, then you are only negotiating primarily on covenants, representation, warranties, indemnification. Okay. Then method of payment, governing law is which law will be applicable to the contract. So this governing law, there are two things. Which law will be applicable to the contract? You can't choose it if you are in India, if both parties are Indian. Only if one party is a foreigner, you can still choose. Then dispute resolution, which courts will you go to? If you are in India, you can exclusively select any one of, where there are there could be multiple applicable courts you could go to, and you don't want a multiplicity of proceedings and you want to choose the forum. So you can explicitly limit that all proceedings will be initiated in Delhi courts only or something like that. But that court has to have some connection with that matter. Only then it will get jurisdiction. Waiver is about giving up your rights. How do you give up your rights? I'll just explain these simply, okay? Most parties say that simply my failure to insist on payment, like if I am to get rent by 7th and for 2 months you will pay me on 9th, the next month, the third month that you pay me on 9th, I say, hey, you had to pay me by 7th. And then you tell me that, no, I've been paying for 2 months on the 9th, so now you should take money on the 9th. You've accepted my payment earlier or 2 days late and not said anything about it. So why should I pay you on the 7th anymore? Now, what you're saying is that I waived my right to insist on payment. And the waiver clause says that if I don't exercise a right, which means if I don't insist for the first 2 months, it doesn't mean that I cannot insist in the third month. Why? Because I have not waived my right. All waivers to be only in writing. So if there's a written acknowledgement that I am waiving my right, and from tomorrow you can pay, from the next month you can pay on the 9th, then it's okay, otherwise not okay. Non-compete and non-solicit are standard clauses where it's written that one party will not take away employees, consultants, or work with consultants of the other party. Typically, this happens when two parties are closely collaborating in an investment relationship or a joint venture where there's actually close coordination between two parties. Non-compete is about not competing with another party, whether by starting your own business or working with a competitor. It can arise in a variety of scenarios. Non-competes are not always valid. They have to be reasonable. And depending on the context, you will see whether it's valid or not. Even if it's not valid, many parties take the risk and then include a clause which is not valid, even though they have that risk, because it may not be clear in black and white and it still has an impact on somebody innocent who joins and who thinks that I have signed this, so I need to abide by it. Assignment is whether I can assign or transfer this contract to somebody else, because if for example the company enters into a software development agreement and tomorrow it's getting bought out or invested into by somebody else, can that somebody else continue to perform these obligations? That's what assignment says. Confidentiality is a standard one. You'll come across these. We'll ask you to draft these. Severability is that, now if you have this one illegal non-compete clause, does that mean that one clause is illegal so the whole contract falls, or does that only mean that the non-compete falls? Okay, now that's what severability clarifies. IP rights clause will say wherever intellectual property is being created or transferred, it will say which party has ownership over it. All your IP laws allow you to assign or determine who will ownership lie with. Then amendment clause specifies how the contract can be amended. Breach, consequences of breach and remedies is very important, okay? As important as the operational clauses. Most people don't know what constitutes a breach of the contract. Like, theoretically what constitutes a breach, but you would not know how in a particular contract, what actions will you call a breach? Okay, that is a problem because there will be a dispute between parties as to what is a breach. Many contracts have open-ended clauses like material breach. It is suggested that you specifically identify the important clauses, the important obligations which don't happen, then it's a breach. Like you will not say, for example, look at it practically. You take a house on rent and some 10 plug points are not working. You will not say that's a breach and give up the house. You will say, okay, get it fixed. So, or you will give the landlord an opportunity to fix it. So what is important that will become a breach? If there is water flowing everywhere inside the house, there's no plumbing, that will be a breach. So you need to identify what is the actual breach, what is the scenario which will be called a breach. For the others, you can leave an open-ended clause like material breach or something. Entire agreement clause says that this agreement, all the clauses, all the papers are actually constituting the entire agreement, and to not rely on prior emails and other exchanges and other communication to say that this is also what our agreement means. So both I had clarified that recitals and preamble are the same. Notices clause says that how do I give notices pursuant to the clause to you. Now what does this mean? Over the duration of the contract, we will give various notices. Notice for disputes, notice for payment of rent, notice for this, notice of change of address, lots of things. So this clause gives you a format as to whom to give notice to. Whenever there is a dispute, this clause is very important because you can have a deemed service clause that if you give notice to this person, it will be considered served. Deemed notice clause is very important and it should always be there because that is how you initiate a dispute. Otherwise, you might send somebody else a notice. You might say that, I forwarded a notice to the company secretary of this company and now I have initiated a dispute. But the court will say, okay, but in the notices clause, it's written that you have to send it to the CFO. So why did you not send it there? And your dispute invocation can get invalidated and the court will say rectify this and then come back to us. What's worse is that you might have sent a notice to discuss mutually to the CS and you might have followed a 1 month procedure. That's even worse because then the court will say follow the whole 1 month procedure again and then come back to us. Okay, that puts you behind schedule then. Okay, then jurisdiction says, as we had discussed, which courts have the jurisdiction. You can include arbitration clauses wherever you want to. Like, so there will be governing law clause, there will be arbitration clause, there will be jurisdiction clause. Jurisdiction can be with one of the courts that have jurisdiction otherwise, and arbitration clause will say that arbitral tribunal of 1 member or 3 members will decide the dispute. You can choose an arbitral institution or you can have the arbitral tribunal. You can pre-name and appoint an agreed upon arbitrator also, or you can jointly agree later on to have an arbitrator appointed. Most parties are unable to agree to this. So what happens is that people go to court, file an application and the court appoints a retired judge. Liquidated damages clause says that for certain breaches, what is the amount payable? This amount under Indian law has to be a genuine pre-estimate of the loss that could be caused. If it is unrelated to the losses that could be caused, then the court may hold it to be invalid. You will need to prove your damage in that case. That's a big problem. Proving damage means you have to put in a lot of documentation. Limitation of liability clause states that whatever happens, your liability is limited to X amount. Usually included in technology contracts a lot. Okay. Force majeure clause says that if certain events outside your control take place, then the obligations are not effective at that time. Exclusivity clause may be there in some contracts. It means that when you're dealing with me, you don't approach other parties. Especially true in cases of investment agreements where there is an MOU or a letter of intent executed. Then there may be an exclusivity clause which says that till you are dealing with us, till our discussions don't fail, which will happen either when a particular date is passed or when one of the parties gives a notice that I'm not going to pursue you. Until then, you are exclusively talking to each other and no one else. And then there's a signature page and then there may be schedules or annexures to the contract. Okay, so that was a whole overview of different clauses of a contract in a quick snapshot. Now,
I have one question.
Yeah.
Yeah, and what, this is Shivani. And what kind of contract do we have this exclusivity clause?
When you're pursuing, let's say, a joint venture situation, or you're pursuing an investment agreement, or you're pursuing an M&A deal.
Oh, okay.
Then what happens is that those contracts are executed in 2 phases. One is the definitive contracts, and before that, you execute an MOU or a letter of intent. Okay. In that letter of intent or MOU, there may be this exclusivity clause. At that stage, you will have only a very broad idea of what the deal is going to look like, and more details are going to be identified after some negotiation by the parties. Okay, at that time, to ensure that both parties negotiate in good faith, an exclusivity clause is indicated so that no party tries to abuse and bargain hard.
Oh, all right. Thank you.
That is to be closed by the exclusivity clause.
Hi, I have a question.
Yeah, who's this?
Hi, I'm Jasmine.
Yeah.
My question is that in a joint venture agreement, there should be initially an NDA or a memorandum of understanding. What do you suggest?
In a joint venture agreement, you will definitely need to have all the clauses of an NDA. Plus, you can have more clauses, and you can call the whole.
No. Before entering into the joint venture agreement, there should be a NDA or a memorandum of understanding.
What will you put in an MOU? More things than
which type of document should come first, NDA or an MOU?
So first thing that happens is an NDA, because before you have any idea and people are just starting to talk, they can't agree to anything else except confidentiality. So your NDA will always come first. If by chance parties know a little more about each other and they are able to agree on more terms, then they will have an MOU where all the NDA clauses are there plus some more clauses are there, which express that, okay, I will make an investment ranging from 50 crore to 100 crore, and the other party will distribute in certain districts of India, which will be finalized post-negotiation, like that. Understood?
Okay. But is an MOU compulsory, or you can directly go for a JV agreement after the NDA? We can directly go. Yeah, thank you.
And your other question on very small agreements like coffee machine contracts. So this seems to be either you can have a standard form for procurement contracts, which is a coffee machine procurement contract. If it's about a servicing thing, you can have a standard AMC contract. Okay, like a maintenance contract. So in that, what you'll do is, that's what the big companies do. They will have a standard agreement and they'll have a schedule. The standard agreement has all the general clauses which are same always, and the schedule specifies the item. So anything that could be capable of change, like your coffee machine AMC might be serviced 3 times a year, or 6 times in a year, but your filter or your AC may be serviced lesser. Now I'm talking about one AC, but you can have for the whole office. You can have a maintenance contract, right? So you might have 100 ACs which need servicing. So those contracts will have a schedule, and you'll have standard terms which are common. Those are actually called the legal terms. They are in the main contract. In the schedule, you'll have the technical details, which is like fill in the blank, you fill it up, and that will be valid. Yeah, tell me.
Okay, and in the procurement contract, all the clauses that you took through in the checklist, do you suggest all of them more or less should be there?
Ideally.